Thank you. Just to introduce myself, my name is Neil Peirce. I work at the Learnovate Centre. So we're a research centre looking at industry-led research in educational technology. So on our panel today, I would like to introduce Kate Colleary. She's expert in kind of data protection and data privacy at Eversheds law firm here in Dublin. Next we have Fionnuala Healy. She's Chief Technical Officer at Gotcha Ninjas, who are a social educational games platform based here in Dublin as well. Next we have Professor Mark Brown, who's head of the National Institute for Digital Learning at DCU. And finally, Billy Hawkes, who's the Irish Data Protection Commissioner. So I'd like to start maybe with you, Mark, around, instead of just jumping into data privacy, about the reasons why we might actually collect this data. What is it that makes it interesting and useful from an educational perspective to start gathering user data to understand how they're interacting, what are they contributing?
Sure, I think you probably stole my line, which is I think what you've done with the title is flipped it from maybe the flipped classroom in action, flipped it from data privacy to educational technology and data privacy. So I think it's very important understanding what the outcomes we're seeking are first and to locate the discussion within those outcomes. For me, it's quite simple, but remember I come with a very strong educational focus, and it's about enhancing outcomes for learners. Those outcomes are short-term outcomes, immediate outcomes, and long-term outcomes that might link to employability, life chances, the role and contribution they make to society at large, both individually in the private good, or the personal good, and the public good. Perhaps drilling down a little bit further, because that might be a little bit of a cop-out answer, the outcomes for learners. What we know is that learning is quite a messy process. We know a lot about learning. It's a science. There's a huge science, but ultimately learning is still quite messy. There are things that I still learn from experiences I had 20 or 30 years ago, particularly through your own children. You'll find that you have those sort of flashbacks to your own experiences as a child, and you're still learning from those experiences. So putting a time limit on it is quite challenging, and that might be one of the issues we bring up. Probably the concept that's most important is one of personalisation. That with the new technologies we have available, recognising that learning can be personalised to the context, to the experience, to what you bring to the learning experience, or what you want to take away from that learning experience. That's a very different concept than individualisation, I might add. So customising the learning to the learner or learners, because we also understand that learning is not something that just happens in the head. In fact, contemporary understanding of learning, it's a networked experience. No individual knows all the knowledge. It's shared across the network. So I think because knowledge is shared around the network, that creates the interface with some of the privacy issues in particular. And then when we start talking about enhancing those outcomes for learning through more customised, personalised experiences, we now have data sets that we can put supports or even interventions, to be a little bit more clinical about it, in place that, based on the evidence, is likely to lead to more successful outcomes. I qualified that because, again, how much data do we need to know? And I'm very wary about using data to make predictions. I think there's some history here that we need to be mindful of in the past. That's probably enough to get things started.
Maybe Billy, would you like to come in there about, I think Mark kind of touched on the idea there of capturing the right amount of information, not capturing too much. And where do you think the kind of balance lies between, gathering enough to make your educational technology, things like personalization and learning analytics effective, but also balancing the privacy and the rights of the individual to maintain a certain distance from what can be inferred from that?
Yeah, I think there's probably two parts to your question in some ways, in terms of what you are telling young people about privacy and to what degree it's being respected, including in the educational system. We do get quite a lot of complaints from that general sector. Obviously, we're all, as parents, precious about our offspring, so when something happens we don't like, we tend to complain about it. We're at the receiving end of it. There is a balance to be struck there. It's, I think, a balance above all about respecting people Once you respect people, and respect usually means you tell people what you're going to do with the information they're giving you, and if it's for the sort of good reason that Mark has outlined, people have no objection to it. And if you were to pick out the key characteristics of people who complain to our office, it's usually when that sort of respect has not been shown to them. They haven't been involved in the decisions about the use of data, and there hasn't been a privacy by design approach, which I know we'll hear about later, to the collection and use of data. So I think data protection is really all about respecting people, and once you do that, you're most unlikely to have any issues, in fact, with the law.
Okay, great. Maybe now I can bring in Alan, if he's with us, yeah? I know there's been a big issue in the States with the In Bloom and the fiasco surrounding that and the lack of kind of trust and transparency. Could you say a few words about that and how the importance of trust and transparency in data protection and data privacy in the US?
Yes, absolutely. Following up to individuals, students.
I think we're having some technical difficulties with the audio here. I don't know if we can.
Do you hear me?
Yeah, I think we're okay now.
Okay.
Yeah, go ahead. Sorry. No, we've lost the audio, I'm afraid, Alan. Okay, I'll come back to you in a minute. Hopefully we can get that fixed. Maybe, Kate, I could bring you in. You're familiar with the In Bloom and the issues there around trust and transparency. Do you have any perspectives from a legal side of things where they didn't actually infringe anything, but the potential to was there? How would you?
Yes, I mean, it was absolutely about trust. It was about the fear of what might happen and the trust that parents had in the local education service providers. And it's, it is an issue both of trust, but also there was the concern, I think, that the parents in that case described, which was the commercialization of this data. And while, as Billy said, people are generally delighted to hand over their data if they're going to either get something in return or if it's for a good cause, the issues arise when something else is going to be done with it, and perhaps it's going to be commercialized. People start using the information or the personal data for other purposes. And I think that was the concern that a lot of those parents voiced, and I think it would probably be a similar issue here. And to some extent it is an awful pity, because the potential upside of that program was really, really positive. And Fionnuala at lunchtime spoke earlier on about privacy by design, so I'm going to let you repeat what you said, but it was, these things aren't insurmountable, and I think a lot of times people feel that lawyers are the people who say no. That's our job. We just tell you, no, you can't do this, no, you can't do that. I say that's not what we do. To some extent, it may be what Billy does, but I think in fairness to Billy, he's a very commercially focused and very commercially minded regulator who attempts to achieve consensus, or attempts to achieve compliance by consensus rather than prescription. I think our lawyers' role is to try and find innovative solutions, how to protect data and manage that balance, and then that will feed in again to the trust issue, and hopefully we won't have a situation where parents would have that concern that they will trust either the third parties or the educational establishments.
Great. Maybe Fionnuala, as a new company starting off in the targeting school-aged students, what can you say on the challenges of data protection and privacy?
Well, when you're talking about children's data, especially children's data which resides in the cloud, it just brings up a whole heap of issues, especially with In Bloom and parents' concerns around that. And a lot of the times people come in and academics go, oh, if we analyse the data, we'll get this end result, and we'll capture the data and we'll do it. And the same with commercial entities, they'll capture data and they'll get a result and the feedback, and they forget that the data is actually a person, it's a user. So privacy by design is a concept primarily driven by the Canadian regulator, which is essentially what Billy was saying. It's about respecting the user and thinking about it from concept and building it into every part of your product development. So every single element along the software development lifecycle should consider the user. And at the end of the day, even commercially, it's a good idea, because if you get something like a subject access request, if you built that in from the start, then you just have to press a button and you'll get all the information without having the costly implications of having to find all the information about someone. So it's more about considering the user through the entire journey and making it a habit to think
I'm sorry, sir.
about
Good
privacy
afternoon.
in every
My
step
name
of
is
your
Peter Nicholson,
journey, in every step of your business.
here. I just
And
want to
that
check.
way
I'm
you
listening
build
to
up
the audio
transparency
from you on headphones. I
to
just want to say
parents,
I'm
and the
not.
parents can see the benefit by
I'm not hearing
automatically
anything from
opting
you,
them
I'm
out.
afraid.
They can see the benefit, then they might be more willing to opt in, and that's the way you get buy-in with your users.
And you're also then achieving compliance by habit, as you said earlier on.
It's not about going, no offense, but it's not about going to lawyers and going, how can we get our product compliant? It's about building it, taking your users and respecting them, and that will allow you then to be compliant with the laws. And then you go, you look at the laws in Ireland and the EU and the US, and they're all different. But if you've followed privacy by design throughout your whole flow, you more or less are automatically compliant with all the legislation.
Okay. Unfortunately, I think we've lost Alan there because a bit of audio issues. Certainly in the US, they have quite established and kind of quite prescriptive regulation around gathering student data, particularly for young students. So there's the COPPA and FERPA legislation. Maybe Billy, would you like to say what's the equivalent in Ireland? Do you think Ireland and the EU in general is ahead of the curve, behind the curve, or how are we going in that regard?
Well, given we're at a US embassy event, I will be careful as to what I say. I certainly heard it asserted by a senior official from the US administration that the standard of privacy is as good in the US, if not better than the EU, but that they do it differently with a greater reliance on self-regulation, with a then a degree of sectoral legislation, and there certainly is some truth in that. Perfect. But I think one of the keys to achieving the sort of commonality that's important to us in Ireland because of the degree of economic interaction with the US is the proposal from President Obama that there be some form of umbrella privacy legislation in the US. But that if you like, the particularities of the US would be recognized, that it would be umbrella legislation, and then, if you like, that would be underpinning sectoral type of codes, which would be developed in cooperation with industry. And now I understand because of the particular political situation in the US at present that particular proposal isn't going very far at present. Whereas here in the EU, when the Irish people for the second time voted in the Lisbon Treaty, we made data protection a fundamental right, and it's now a separate right to the right to privacy, and that in turn is the basis for more prescriptive law, which is coming down the track from the European Union. So that unfortunately will create an increased divergence with the US approach, and of course we have then the discussions at present around safe harbour, which is the key mechanism for transferring data legally from the EU to the US, but at least arising from that, there should be some further movement on the US side, which will be helpful. But certainly there has been, I think, an increasing attempt to achieve a degree of convergence. But I think it'd be fair to say there's a fair road to go before we could say that, to use the US phrase, there is genuine interoperability between the two regimes.
Okay. With the kind of continuing evolution and innovation in educational technology, we see sort of the emergence of things like MOOCs or massive online open communities for learning. This opens up new kind of opportunities for learning, but also new challenges in terms of data privacy. You've now got, instead of a few hundred enrolled in an educational course, you might possibly have tens of thousands, and you're gathering a lot of data about them, about how they're interacting with the systems, and what they're contributing a lot of personal, quite identifiable information into these systems. What do you think, maybe Mark, would you like to talk about kind of MOOCs in terms of the benefits they have versus the challenges around data protection and privacy, or also the fact that as educational technology kind of evolves, we don't yet know what data we will be capturing and how significant that will be?
Sure, of course, MOOCs are the flavour of the year, or were last year, maybe losing a little bit of their gloss. I think the first thing, just to reiterate the point that's been made, is the need to adopt a sort of principled approach. And so following the respect of the person, one of the things in the MOOC context is making it very explicit to the participant what's being collected from them and why it's being collected, because I think that's another basic principle that you have a right to know. Now, if that, coming from my education perspective, is being collected in order to enhance the educational experience for them, I think I'd endorse Billy's point that most people would not have an issue with that. The challenges in an area which we are relatively uncharted water is some of the MOOC platforms are commercial platforms. The data that's being collected could be on-sold, and some of the terms of reference, if you drill down into the very fine print, that is the case. It's not, or I'll rephrase it, it's not precluding the commercialisation of the data with other partners. And if you're not aware of that, because I think for me one of the basic principles, if we're trying to generate half a dozen principles, is informed consent. So ticking a box at the bottom of a login page is not informed consent. And in fact, we have an obligation, in the case of MOOCs, the providers, to tell it in plain language. Yes, you can have the long legal piece that needs to be done for legal purposes, but if we're not saying it in plain language, then we're quite simply not following the principles. It does concern me that people, particularly we know in the MOOC platform, very, very high non-completion rates. Many of the mainstream ones, we're talking about 10% probably complete. So how might the non-completion be used at some point? On the other hand, on a more positive note, having led a MOOC platform initiative where I've come from in New Zealand over the last 12 months, I can say quite conclusively we learnt a lot from the experience of the learner that has fed back into the design for learning. So my hand in my heart, I feel quite with some integrity, if you like, that what we were doing was indeed feeding back into the learning experience, not just of those learners, but of other learners. And for me, that's where the conversation we're talking about is not an exact science. There are no hard and fast kind of right and wrong answers here, it seems to me. We need to create an environment where we are discussing the issues. I'd be very concerned to see us create an environment of compliance and feel like somehow we are being compliant just because we have ticked all those boxes. So the MOOCs are good, I think, metaphor, a good case study for a whole raft of things that we really still don't know, particularly in the era of the so-called big data, because we can join all these things up now and have a much more complete picture.
Great. Fionnuala?
Just on that, when you're talking about big data, you got multi-jurisdictional issues there. And then on top of that, you've got emerging technologies, innovation, and it's very hard for regulation to keep up with that. And so you're looking at legal firms trying to be compliant with regulation, which doesn't really apply yet to the technologies that's been invented. And so when you come to something like MOOCs, it's like, was that even existing when the current data protection legislation came about in Ireland? And then also on top of that, when you start looking at something you mentioned earlier on is about the users and the transparency. In the US, they're a lot more aware about data protection than they are in Europe, and that's because of In Bloom. So when you go over there and you talk about education, everyone talks about In Bloom, and it only takes one incident to really make people aware. And something that, from a commercial point of view, you need to be aware of when you develop a product and you give that to somebody for a school or university to implement, you're also giving them obligations in relation to the data that they're collecting. There's a certain educational responsibility, I believe, on the creator of that product to inform people on their responsibilities as someone collecting data.
Maybe Kate, do you have any kind of view? You're obviously engaging with companies in Ireland regularly on data protection, data privacy issues. Do you have any feeling that Irish tech companies are being proactive about their approaches, or are they being reactive?
Unfortunately, I'd say a lot of them are blindly oblivious to some of the issues, but that is changing, and I think our Data Protection Commissioner's Office does a great job in the education side of things and publicising data protection issues, and that is one of the functions, is to educate people, as Fionnuala said. I am one of those people. I don't believe that legislation, and I don't believe legislation should prescribe certain technologies or limit itself to technologies. We don't have the ability to change our legislation every year to keep up with new technologies. So both in the intellectual property field and in the data protection field, we have a set of rules that apply regardless of the medium. So regardless of how the data is being processed, how the data is being dealt with, you still have to inform data subjects. You still have to process for certain reasons. You still have to confine yourself to the purposes for which you've informed the data subjects. And that applies whether you're talking about a manual filing system or whether you're talking about the most innovative software you can possibly imagine. So the same rules apply, and I don't think it would be possible for any country in the world to try and match their legislation to technology. I'd be interested to hear what Billy says, but I mean, I would use Billy's analogy at the outset. You know, it's about fairness. And again, what Fionnuala said, if we can build in the data protection element at the outset, and then as the technology and as software is evolving, that software is naturally going to comply with whatever rules are in place, because you've got that mindset at the outset.
And how do you think we sort of foster a sort of environment of privacy by design? Do you think that's something that's going to have to be legislation that we follow, or do you think there's other approaches?
I don't think. I think that it's going to be driven by commercial necessity. I think a lot of companies are adopting it because it makes sense. I would do some work with LinkedIn, with Facebook, and some of the other social media companies, and you know, their whole business model is based on trust. And if they don't have the trust of their data subjects, their business is down the swanny. So forget about them, you know, complying with data protection regulations because Billy is going to give out to them or fine them, whatever. They're much more interested, well, no, no disrespect, but it's incumbent on them to have the best privacy and the most robust privacy systems that they can in order to have a viable business. So I think it's going to be commercially driven. I think it's going to be companies realize that this is now becoming a real issue. And if they can deal with it at the beginning, it's going to be cheaper because they can develop their technologies around it. And it's going to foster further trust, as we saw in the US. So I think it's going to be commercial. I don't think there would be necessity for legislation, but I would be interested on Billy's view on that.
I think we generally find US multinationals that set up their European headquarters here, that they're generally anxious to comply with the law. There are challenges for them in European data protection law because it is more prescriptive than what they're used to in the US. I think reflecting what Kate and Fionnuala say, we certainly try to get them to realize that their commercial objectives and data protection law are largely aligned. I mean, the key point is the trust of their customers, then basic things obviously like security surrounding data, and that to recognize that in fact they should see this alignment, that if you like, there's a reason for data protection law, which is to respect people essentially. And certainly we find that approach when we carry, because with all of these companies, we systematically prioritize them for an audit, and we go through all of their practices, recommend changes in a best practice direction. I won't pretend that some of these aren't challenging for the companies. I had one angry general counsel telling me, "You're such a horrible regulator that we would recommend any country other than Ireland for setting up." But anyway, hopefully, on reflection, I won't say whether she or he might perhaps not have fully meant it, but shall we say we are fairly rigorous in the approach. But we like to, if you like, have the full and frank discussion behind closed doors and come out smiling when they see it our way. But generally, to be fair, we do find an anxiety to generally to be seen to be behaving well. I think a recognition that the commercial objective, the trust objective, is largely aligned with the data protection objective. So once we can see eye to eye on that, then we're all happy.
Great. Maybe Mark, would you like to talk a bit about data protection within education and within higher education. So you're obviously very heavily involved with innovative digital technologies in education. This sort of, it's not a commercial generally approach, but it is going to capture a lot of data, and for a lot of very good reasons. How do you think educational institutions are actually addressing this? Are they being proactive? Are they?
I think probably there's a degree of sleepwalking, and I might sound irresponsible, but this is not an area that I lose sleep over. I let others think about it. It's clearly something professionally we do have to take some responsibility for. I suppose if there's an excuse, that focus on the outcome. In higher education, third level education, particularly with the advent of the learning management system, the MOOCs type system, but this is generally more sophisticated in some respects within the university context. Learning analytics or academic analytics in the last 18 months to 2 years has become a quite bona fide area of research. There's quite a distinction to be made between learning analytics and academic analytics without being too academic. The learning analytics is more about what happens in the individual course or module, whereas academic analytics is really about aggregating data to understand at an institutional level or a system level. And that's at least one definition. So perhaps two examples that might be useful for feedback or at least to share. The first is the learning analytics area, I think, like a lot of new fields in education, begins with a great deal of hype, and people jump onto the bandwagon, and now we're starting to see the critics start coming through. We've been collecting data on learners forever since we've been able to. And quite frankly, I don't think we've particularly followed the principles that have partly been espoused here by making them aware of why we're collecting the information. Probably for universities, there's a box that you tick on enrolment, and most people accept that the university needs some information from you. Simple things like most universities do student experience surveys or the teaching evaluation survey. It's only in recent times that teaching evaluation survey does the system itself allow the results to go back to the student. They've just been retained within the university, and who knows what's happened with them. So I think that's a level of immaturity, if you like, within the sector. What's happened at the individual learning level and learning analytic level with the literature now is a move away from this way in which we can gather all this data to asking the question, how can we aggregate the data in some meaningful form and share it back to the learner whilst they're still learning? So some of the systems now, and this is really flipping it on the head, and I'm talking probably still a minority view thinking like this, producing dashboards for learners as they're studying, that they're able to get a sense of how they're tracking. This is to promote reflection, critical reflection, perhaps compare them against other learners at the same point in the course, although these are questions that need to be discussed because there are assumptions built in. So for my mind, that's a much more positive way to be thinking about how we can use the data constructively to achieve the end outcome of enhancing outcomes for learners, where ultimately learners have to take some of their own responsibility. Very quickly, my second example comes from New Zealand, from an experience that I've been involved in, and we haven't talked at this stage about the role that governments play, which is often one of the fears that people have. New Zealand, like a small country similar to Ireland, you can do things without the complexity, shall we say, of the states. So our government has had a project underway for the last 2 years, data matching quite serious sets of data, including immigration, school achievement, income level, university qualifications. And my own university chose to participate in this study, to be in the tent rather than out of the tent. The real interest for this data matching, this big data, comes from our politicians and policymakers who want to be able to answer questions about where do we best put our public funding for particular interventions. There's a worldwide intervention known as reading recovery. What we're now able to do with this data, and I know from the experience that I'm describing, look at the outcomes 10 years on for children who have had interventions like that to help decisions about public funding. Now, I think that's a really challenging area for governments to be in. Firstly, rightly, it's public money, but balancing the responsibility of the individual and the data that's been gathered within the public right, to my mind, is a very, very murky area.
Big challenges in terms of the benefits, which are quite clear, and can, in terms of policy and how we can actually direct government policy based on this evidence, and actually protecting the individual. You'd mentioned earlier about kind of the idea of lifelong learning and gathering data over a very long period of time. This is something that we're only realizing now. We haven't been gathering this data all for a long time. How do you think in the next 5, 10, 20 years we're going to actually start seeing the repercussions that there is so much data being captured about us, and there is benefit, but there's also big risks associated?
Very briefly, and I think other panel members are probably better placed to answer that than I am. The ethos that I would bring to that issue is really one of giving the data back to the person so they can make informed decisions about how that influences their choices in the future. I do think a point was made earlier, though, the responsibility comes for us to educate people how to interpret the data.
I like the idea of transparency and telling the learners what you're capturing and how it's going to be used, but actually being able to examine their own data. Maybe Fionnuala, have you come across those sort of approaches, or?
It's just something I was thinking about there is just because you can do something doesn't mean that you should. And this comes more from aggregation of data. And if you look at the likes of league tables, and something they did in the States was in education was a thing called stacking, where they bell curved teachers and got rid of the bottom few. It's important to understand that you're using data and getting the correct and interpreting it correctly. And I think this is where sometimes commercial entities have to take a lead from academic institutes. So I think, there needs to be a bit more flexibility in the data that they use and how they apply it, and letting universities and academic institutes to kind of find out what might be a good way of doing it, and then allowing the commercialization to take a lead from that. When it comes to getting feedback, what Gotcha Ninjas is trying to do is kind of, in some ways, replicate what's going on in the classroom, which is recording what's going on in the classroom, assessing it, and feeding it back to the student, to the teacher, and to the principal and parents. And all you're doing there is creating a feedback loop, which I think is exactly what Mark is saying. Is like, what you're trying to do is kind of make data meaningful, but you have to make sure that the meaning is right.
Okay. Great. Perhaps we'd like to maybe open it up to a few questions from the audience. Is there any questions for any of the panelists? Anyone? Can I just? Oh, yes. I won't. His mic's coming.
Good afternoon. I may have missed the point earlier on, but I did catch some of the reference to the Safe Harbour scheme. I know particularly, less so in New Zealand, but certainly in Australia, there was some maybe less positive results recently from evaluations that were done of the Safe Harbour, particularly in terms of the governance and the accuracy or the currency of the data in the register. Could you speak briefly on that point, possibly, Billy, just how Safe Harbour is perceived and the current status of the Safe Harbour scheme? Thank you.
For those who know, Safe Harbour is a special deal between the European Union and the United States, which allows personal data of Europeans to be transferred to the United States on the basis that the companies in the US will sign up with the Department of Commerce to basically they undertake to comply with European standards in relation to the data, and if they fail to do so, they face enforcement action from the Federal Trade Commission, which is a type of enforcement action you do not want to have if you're a company. Partly linked to the controversies about intelligence access to data, there has been an examination on the EU side of Safe Harbour, arising out of which the Commission made a series of 13 recommendations to the US side with a deadline of June, which essentially involved things like the Department of Commerce perhaps being more proactive in terms of policing companies who signed up, in terms of companies who mightn't be keeping their registration up to date, doing spot checks on them, and so on. And that process is being negotiated at present. Recommendation 13 talks about intelligence access to data, which is obviously something which is being discussed at a higher level also in the between the EU and the US. I would be, I think, moderately confident that the outcome will be a good one. In other words, there will be a tightening up of the oversight of safe harbour with a view to protecting, if you like, the personal data of Europeans. And on the other side, the vital nature of keeping data flows open between the EU and the US will be protected. And this is, of course, particularly important to us in Ireland because of the number of US multinationals which have set up their European bases here, and more generally in the context of broader economic relations between the EU and the US in the context of this transatlantic trade and investment partnership. Obviously, it's important that data protection, on the one hand, assures to Europeans their data is protected when it's transferred to the US, and on the other hand, that data protection law is not an unnecessary obstacle to commerce.
Yes.
Thanks. Schiefer Flood from Swerve. I have a question about the difficulties being caused to companies by differing perspectives across the EU as to what is personal information under data protection legislation and what's not. For example, I know that the German Data Protection Commissioner considers an IP address to be personal information. He's thankfully in a minority at the minute, but it's very difficult to get a firm view for companies in order to develop their products such that they're asking for consent at the right spots and not. And I suppose as a second corollary question, I'd be very disappointed if we didn't bring this up. In addition to that, I think that COPPA in particular is extremely relevant to the people in this room, because you're dealing with education, which means that you're dealing with people a lot of times with information from younger users. And as an adjunct to that question, like the definitions of personal information under COPPA are different again from both EU legislation, US legislation, and then COPPA itself. So I suppose the first question is, how do we know what's consistent? And the second question is, how do you think that companies are going to be able to deal with the introduction of yet another layer of definitions via something like COPPA?
Okay.
That's obviously directed at me. I think, yes, the good news and the bad news is that the challenges faced by companies because of differing interpretations of the law have been recognised at EU level by the proposal from the European Commission that there be a directly applicable regulation which would apply in exactly the same way in Ireland as it does in Slovenia, as it does in Germany. That's the good news. The bad news is by essentially, and the same would be true in the US, once you come up with overarching legislation, it tends to be more prescriptive. So the draft law coming out of Brussels, the draft regulation, is more prescriptive than the current European directive. But at least that point is being acknowledged. So you should, if you like, see if the regulation comes into effect, you should see a great reduction, indeed an elimination ultimately, of any differences on interpretation of basic concepts like personal data. On the COPPA point, I feel your pain. You know, it's a different country, a different set of laws, and I think, as Fionnuala said, if you want to do business with the US, you have to recognise the quite prescriptive legislation that applies there to protect children, which is the Children Online Privacy, isn't it? That's what it's called, for those who don't know what COPPA is.
Any further questions? Mark, did you something you wanted to mention earlier?
I just thought that a good point was made 5 minutes ago around just because we can, we shouldn't necessarily collect the data. And one of the things, particularly in third level higher education, but right across the education sector, that there is this performance tendency to measure everything we possibly can and be starting to share that back. And the reference to league tables. I come from a country that's very dominated on publishing league tables, top 10s for all sorts of things. we have to be very wary about the validity of what we're capturing in the first place. So for me, I'd much rather have the discussion around what we're collecting and how valid it is before we worry about whether we should be collecting it and then sharing it, or how we should be sharing it. So some of the tables of data that are finding their way into the public arena, newspapers and the like, don't necessarily have the validity that is given to them in the public domain. And we can only hope people interpret those data in ways because of the commentary that comes with them when they're released. But that is a concern, because ultimately, I think the point was made earlier, what gets measured is ultimately what gets done. And the danger, particularly with our teaching profession, is if we adopt very narrow measures, and assessment I'm referring to here, where we really identify assessment in such a way that that's the measure of performance, then we know from what's happened in the past that teachers will simply change their behaviour to teach to the assessment, and that's no measure of performance whatsoever, and certainly would be no benefit to Ireland as a country at large.
Yeah, I think that's interesting in terms of the idea of only capturing what is kind of essentially necessary. And I was talking to Fionnuala's colleague about this recently, and he mentioned the States, they've established recently a hotline where you can dial a free phone number to get, if you're like a teacher, or if you're a parent, or if you're a company, you can ring up and get information about data privacy and whether you might be infringing it or companies infringing your rights. Do you think something like that on a national level, Billy, might be a good way to go? Or
I suppose we are that at present. We operate a very active helpline where anybody can phone us up and ask a question, and we see it as a very important part of our function to both explain to people what their rights are, and also explain to companies and other organisations, including state organisations, what their responsibilities are. But certainly we'd be delighted to share it if someone else would like to come up with a hotline. But there are things like, for internet abuse, there's different hotlines in that area in terms of bad material. So particularly for children, I think there are quite a number of bodies dealing with children's privacy or issues related to children's privacy in Ireland. I think that they're not perhaps as well known, but there is a hotline run by the Internet Association here, so it's said we're not the only source of if you like, of information, but we certainly regard it as an important part of our job.
And just on that, again, it comes back to how much do people, like the general public, really know and understand data protection? How much does a stay-at-home parent know? And if they look up the website, it is quite legal terminology, because that's what it is. And knowing that there's going to be a friendly answer at the end of the line isn't something that, get in contact, that's fine, but they mightn't necessarily feel comfortable. And that's why maybe in the US, and they use the term hotline, you can call us any time. It kind of encouraged phone calls. And then again, Enda Kenny hasn't had the best experience with that lately. So.
Joan Mulvihill, the Irish Internet Association. I was just looking at the wall and thinking about smart people, smart economy, and a lot of this morning's session was on entrepreneurship and what skills we need as a country for entrepreneurs. And it strikes me that we're talking very much now about data protection in the context of children using it. From an education perspective, from what we're teaching in schools and universities, do you think, or what do you think we should be doing more in terms of educating students in universities? If they're going to go and set up your own business, if it's your manufacturing, it's probably not a good idea to pump your wastewater into the nearest river. You don't need the EPA to tell you that. To what extent is it intuitive that people really understand the data that they're gathering and how it should be treated responsibly? And do you think we should be doing more in university in teaching the STEM subjects, but also business subjects to entrepreneur and innovation students, that there will be some module that deals with this, so that you get to a situation where Fionnuala is talking about, that it is intuitive and is built in from the start, rather than waiting for someone to mess up and then have to ring the solicitors afterwards, or make elicit little calls to the Data Protection Commission going, have I really screwed up, and please tell me. So how can we build that into the education system more, so people are much more aware?
Mark, would you?
I think clearly there's a lot more that can be done, but the one example that I think is useful is the AACSB business accreditation, which is widely recognised throughout the world. 10 years ago, business ethics was not something that you would have seen as a mainstream component, whether it would be a standalone module or woven throughout the whole degree program. A contemporary business school now couldn't be called a contemporary business school if that wasn't the case, and the accreditation bodies have a role to play. I think also, though, my comment earlier that there's not an exact science here. So, you know, we just don't know what we don't know. I think what's really useful is case studies. If we're able to document some of these cases and use them as discussion points to tease out, because there may well be, and history probably would tell us this, debates going on in the future as to whether actually the right decision was made at the time with the benefit of hindsight.
Yeah, just on that point, I was lucky enough to visit a couple of charter schools in the US earlier in the year. And in one of the schools, they had a certification course on cybersecurity, and covered a lot of issues around keeping your data safe online, controlling your access to who you say you are when you give out information that's personal and private. And that's, the charter schools in the US are a little bit more progressive. They're sometimes a little bit more broad in their approach and their consideration for how the learners are going to, the world they're living in. And that's certainly something that we could start considering at a kind of a secondary or even a primary school level.
As part of the Stay Safe programme at national school level, perhaps. I know they certainly do deal with WebSense, but perhaps a bit more in depth.
Yeah, that's right.
And also, if you think about what was said earlier on about data science being like the go-to career, it should be ingrained in any course that goes on in data science. And obviously, I'm an advocate of privacy by design, but like just to get that thinking in there. Certainly, when I was doing my engineering degree, it was take everything and interpret it and do what you want with it. There's no consideration for the user. And particularly as we get more and more towards user experience and thinking about the customer in product design, it's going to be more relevant to teach it as part of a program, ingrained in the program, not just as a standalone module.
Is there a shift in attitudes in data privacy generation Y and Z? I guess some of us are more sensitized to a European approach versus an American approach. What about the intergenerational attitudes, regardless of country?
Yeah, I can say something if you want on it. I think it is gradually seeping in there. It's not necessarily nice. Analogy might be how adults in Ireland, parents are being influenced about how they recycle and use energy efficiently because their children are aware of these things, and they're informing their adults, their parents, to how to actually, live in an eco-friendly environment. If we can start looking at, if you target the children and start bringing it in at that level, it'll last them their whole lifetimes, but they will start influencing their parents as well. So I think it's slowly getting there. I don't think certainly people I went to college with still broadly are very naive to data privacy. They just sign up, they tick the box. And there is we became accustomed to ticking the box. We were the first ones to see it, and it was just, oh, sure, it's grand. So I think there is a lot of work to be doing, certainly all across the board.
I think you're seeing a generation that's coming through now that, it's like if a tree falls in the woods and nobody hears it, does it exist? If I don't post something on Facebook, was I really there? And that's become the norm. Sharing photographs, sharing very personal data through all of these social media sites is now the norm. And that, coupled with the naivety, as you've referred to, can be quite dangerous, because technically there's consent. Whether it's informed or not is another issue. But I think that's the difference you're seeing. And I think Billy and I were speaking at an event with Minister Shatter. Actually, it was an American Chamber of Commerce event last October. And he said he'd never have a Facebook account, and that's our Minister for Justice. He would never engage with that. And if you look at that compared to the kids who are coming through, the trainees, the kids in college nowadays whose whole lives revolve around this, there is definitely a generational gap there.
Do you think is an issue with trust and mistrust being applied to these large companies, particularly the likes of Facebook, or I know Google have been criticized for their use of some of their apps in school settings and the data that is collected and is not collected? Do you think there's a a big issue there around trust being misplaced?
Again, it's trust, and it's also, as Billy said, it's being fair. It's being fair with people's data, so that, you know, if Google want to come into schools and support and sponsor, and in return there's something to them, well, that's okay, as long as there's informed consent, as long as people are aware of what's going on with their data. And I usually say to clients, you know, make sure that the data subject has no surprises. Then it's less likely to be an issue, as long as, you know, there are no surprises when that comes to the collection of data, when it comes to the processing of it, when it comes to the transferring of it, when it comes to the retention of it, no surprises, you know, and it's a pretty basic concept, but I think it echoes what Billy said earlier on.
I'm Jean Kelly. I'm a privacy lawyer at Mason Hayes and Kern, and I'd echo a lot of the points that have been made there. I mean, I suppose two observations I'd have is that the market in this space has become a lot more sophisticated. We've got a team of about 10 in this space, and honestly, I could set up an employment agency for clients looking to hire privacy, product counsel is what they're called in the States, but privacy counsel, who are, you know, 4 or 5 year qualified lawyers who know their way around tech products and who could advise in a business-friendly way in a young company. I think they think I kind of hide them in a desk in my office. I wish I did.
You do, Jean.
Yeah. So there's probably 15 or 20 lawyers in Dublin alone who do nothing but privacy law all day, every day. And they do software privacy or product privacy law. So that's on one end of the spectrum for the very sophisticated companies. At the other end, I go to a lot of startup events, and I went to one in Google last year, and I really noticed a big kind of cultural change. They had a panel which did a sort of a mock Dragon's Den, and that was just young people in the panel, I'd say no older than 30. Every single one of them grilled the startup companies who were there on how they had built privacy into their products and had they complied with the acts. And I was geeking out because they were actually naming the acts correctly, including the 2003 Act. And they were kind of fake VCs, if you like, but some of them were junior people in the VC company. So I suppose the point is, the market will demand it, but also investors demand it. So if you're investing in a company, if I'm investing in a company and I see a very childish or very immature attitude to data privacy, you're not going to invest in that company, because the first they're going to hit with is either a fine or an inability to access a market. So that's just a few observations. And I keep saying to younger lawyers, specialise in this. It's a great area for work, as long as they don't compete with me.
Great. Thank you. Anyone else like to add anything? No? I think we're about at time. So I'd like to thank our panel. It's been a very interesting and engaging discussion. Thank you.